Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic is, how do we respond to the dilemma, developing a data portability solution? On last week's episode of Our Curious Amalgam, we talked about what data portability is and the various competition and privacy implications of data portability. Please go check it out if you haven't yet already. In today's episode, we're going to devote some more time to dive further into this ongoing debate and into a possible solution for analyzing the issues surrounding the portability of data. Joining me today is my co-host, Kayla Odom. Hi, Kayla.
Hi, Christina. It's good to be back.
So, Kayla, can you remind our listenership what data portability is and why it's important?
Sure. So, as you said, we previously learned about the concept of data portability, which at a basic level refers to the ability of consumers to move their data from one source to another or to the consumers themselves. The right to data portability has been codified in Europe's General Data Protection Regulation, and California's Consumer Privacy Act includes data portability requirements. There's also a variety of sector-specific laws that require certain information to be provided to consumers, such as in the financial and health sectors. So data portability is a hot topic right now, and the pros and cons from both competition and privacy perspectives are being debated.
Great. So what are we planning on doing today, and who's our guest?
Well, now that we know what data portability is, what's next? How can governments, sectors, or companies develop solutions for data portability that encompass the often competing goals of promoting competition and protecting privacy rights? Today, we're going to be talking with Peter Swire, who has done extensive research on data portability. The result of Peter's research can be found in his latest article, The Portability and Other Required Transfers Impact Assessment, Assessing Competition, Privacy, Cybersecurity, and Other Considerations. We've got a link to Peter's article on our website. Peter has developed a framework that can be used by policymakers, companies, or others to evaluate initiatives for portability and other required data transfers, and today we're going to learn about it. We're really excited to have Peter Swire as our guest. Peter is an internationally recognized expert in privacy and cybersecurity. Since the 90s, he has had extensive experience in government, academia, and in legal practice. During the Clinton administration, he served as the chief counsel for privacy in the U.S. Office of Management and Budget. Under the Obama administration, he was special assistant to the president for economic policy and served as one of 5 members of President Obama's review group on intelligence and communications technology. Peter has testified before the Federal Trade Commission on privacy and antitrust and spoke at the FTC's Data Portability Workshop. Peter is the Elizabeth and Tommy Holder Chair of Law and Ethics at the Scheller College of Business at the Georgia Institute of Technology and a senior counsel at Alston & Bird. So with that, Peter, welcome to the program.
Glad to be here. Thank you.
So there are a lot of unanswered questions right now about the pros and cons of data portability. What would you say has led to the increased importance of data portability issues right now?
Well, at the simplest level, data portability is about opening up data flows in our data economy. But privacy and cybersecurity sometimes close down data flows in our data economy. So that's a big picture. When to flow data or not is a huge issue for so many different industries, and portability is the way we talk about a lot of those conflicts.
So earlier I mentioned the Europe's General Data Protection has a right to data portability. And California has a privacy law that lists out portability requirements. Would you say that those more recent laws are affecting the discussion in the United States?
Sure. My paper talks about 3 reasons this issue is important right now. The first is California's law went into effect in 2020. GDPR went into effect in 2018. So there's a compliance issue for services to be able to provide their data back to the customer or to a different service. The second reason is people are very interested in the online platforms, Google, Facebook, Amazon, et cetera. And a lot of people have proposed that for antitrust reasons, we should open up data flows in certain ways to provide more competition. And the third reason is that we've had sector by sector rules, including one pending right now in the financial services area for the U.S. and one that has been issued by HHS for healthcare. So we have these sectoral initiatives happening at the same time. So all of these give us reason to be trying to figure out portability right now.
How would you summarize the ongoing debate surrounding competition, privacy, and cybersecurity aspects of data portability?
Right. Well, so I've taught antitrust law in addition to privacy and cybersecurity, and my paper tries to come up with a step-by-step process for thinking about these different issues. Basically, on the open up data flow side, the competition idea is maybe more people can use the data, use it to create new products, use it to compete on better services. Another reason people like portability is for individual freedom or user choice, right? Wouldn't it be nice for you to be able to move your photos, move your documents from here to there? So those are very important reasons to open it up. On the other side, when it comes to privacy, at one point, Facebook opened up its data to Cambridge Analytica. And it got a lot of criticism for that because people said that was a privacy problem. Or if any service opens itself up and it turns out that hackers pretend to be you and get all your data, then that's a data breach. So you have to build against the data breach. You have to think about privacy. Those are reasons to be careful about data flows. But we want to have robust flows for a lot of competitive economic reasons and free choice reasons.
And is there risk here for conflicting legislation? Given the various streams that are focused on this today?
Well, sure. So you could imagine from the privacy or cybersecurity side that there's very strict rules, and that might miss some competitive opportunities. You can imagine antitrust enforcers saying, open up the gates, let the data flow, and that might lead to privacy and security problems. And so to address that, the idea of my paper is to give a step-by-step of how to do an analysis, like a privacy impact analysis, but it's a portability impact analysis. Do an analysis so you work through the antitrust issues, you work through the privacy and security issues, and you have a chance to spot what the problems are and come up with something, hopefully, that meets the conflicting goals.
So what led you to your latest research, and what inspired you to get further into this?
As you said in the introduction, I've been in these fields for a long time. So I started writing about the intersection of privacy and antitrust in 2007 testimony to the FTC, when I proposed that one way to think about how privacy and antitrust fit together is that privacy can be a quality or non-price aspect of competition. And so I published that back 13 years ago. That's an approach that I think has gotten more accepted since then. Senior officials have said it. Then when GDPR, the European law, was proposed, with a co-author, I wrote an article in 2012 and 2013 saying, here's how data portability works. Here's what some of the issues are for antitrust and privacy. And then the next round is, for reasons we just said, these laws are going into effect. These case studies are happening, and people are worried about the platforms. So it seemed time to try to bring that previous research up to date.
So tell me what the conclusion or the results of your research are.
Well, some of the results are procedural, which is that single issue regulators, privacy or antitrust regulators, really can miss it unless they think through what's going to be the impacts in different directions. So we need a more integrated approach. So that's a procedural kind of answer. I think another answer is that for the antitrust people, and this is the antitrust section as the beginning of its name, portability really turns out to be about lock-in, right? If things are open and the data is flowing already, you don't worry about opening it up. You don't worry about portability. But if there's some kind of lock-in effect, like you can't get stuff out of a monopoly provider, or a lock-in effect, like switching costs are very high, that's when you should, at least for a competition point of view, consider maybe having a portability requirement. So that's, I think, one important thing. Another issue is it turns out that people, when they make arguments here, often are self-interested, right? So some people have the data and don't want to share it, and they'll come up with excuses not to share it. So, for instance, in the banking area, where there's been in Europe and the United States some discussion, in the banking area, the traditional banks want to say things like, oh, it's a cybersecurity and privacy problem if we let you move your data to Plaid or Intuit or Mint or one of these other services. And the other services say, wait a second, we believe in cybersecurity, but you're using it as a pretext. You're using it as an excuse to lock in the data and make it hard for consumers to get the services they want. So one of the things to look for is, when is the asserted argument about privacy and cybersecurity valid, and when is the argument maybe a pretext? And so the paper tries to come up with some guidelines for guessing based on the facts, whether it's a real excuse that's based on good things or whether it's not such a good excuse based on a pretext to try to keep market power. So the paper goes into that. Go ahead. Yeah.
Can you walk us through some of that framework that
Sure.
should be assessed?
Well, the framework starts in some ways with very ordinary cost-benefit analysis. Step one is you have to define the data flows. On any of these issues, until you say what is going to be moving from where to where, you can't assess whether it's a good or bad idea. Step two is, what are the benefits? And a lot of the benefits might be for competition and innovation. Some of the benefits might be for freedom of user choice. And some of so those are the things to look at on the benefit side. And then look at the risk side. What are the privacy risks? The privacy risks to my data if it gets ported, the privacy risks to somebody else's data if they show up in the photo, for instance. What are the security risks? Has authentication been done well to stop the hackers? Is it secure in transit with encryption so that bad people can't get hold of the data? Are there good standards in place so that the data is being shared in a good way? And there's also risks to competition if you do portability. So if the three biggest companies in a sector get together and design a portability regime, that might help the three big incumbents and hurt everyone else. So with standards, there might be an antitrust risk from portability. And so, I have 14 structured questions. You go through the questions. These questions were based on a set of case studies from Europe and the United States. And if you go through the questions step by step, I think you can come up with a pretty reasonable assessment of some new proposal for portability.
And so I think the questions are really helpful for outlining all the various issues that someone should be thinking about.
Mm-hmm.
How do we quantify? Are there tools to quantify, right, the cost-benefit analysis? And we can say, okay, here are the costs that way the benefits, or vice versa.
I think it's, in many instances, you're not going to get a very good quantitative assessment. This is, OMB, Office of Management and Budget, for years has done cost-benefit analyses of regulations. And the guidance that Cass Sunstein helped lead during the Obama administration talked a lot about when you can quantify how to do it, but then how do you handle the soft variables where you can't quantify? Mm-hmm. And I think a lot of what's going on here is you probably want to have a multi-person team, some people who know the antitrust stuff, some people who know the privacy and security stuff, some people who can have some sense of the sector to see what's actually doable in the sector or not. But if you have the structured questions, and we've tested the structured questions against 8 case studies. So first I had a draft of the structured questions. Then with some research help from the Alston law firm, we did sector by sector case studies, and then came out with sort of revised structured questions after having studied the case studies. I think with the structured questions, people can do a pretty good job of figuring out what the biggest risks here. And the Federal Trade Commission, in their workshop, they asked me to be the introductory speaker to lay out the framework. And I think it's because regulators are comfortable with the idea that there's a set of issues that have to be considered together. And what's done here, I think, is in some ways is codifying common sense, but it's codifying common sense across these different domains of privacy and antitrust and cybersecurity, where people hadn't taken the time perhaps to put it all together previously.
Is there a need to be able to answer these questions on a larger scale? You mentioned that it's sector specific. So for a particular sector, let's do the analysis. Let's walk through the costs and benefits. Is there any way to take this to a bigger level? Perhaps
Right.
To create a larger regulation in the U.S.?
So if the U.S. goes ahead and passes a privacy law in the next Congress, which it might do, there's reasons it might go that way, pretty much all the proposals have a basic data portability right included in it. That's similar in a lot of ways to the GDPR European right or the California right. And it would basically say in pretty simple terms, when it's feasible, a user ought to be able to move his or her data from your service to themselves or to a competing service. And so that will be across sectors. A lot of the antitrust action has been, maybe we should open up whole databases. Maybe we should do what the Europeans call data sharing. And for that, it's a much more sectoral antitrust. What's the market definition? What kind of portability initiative makes sense? So I think a basic individual right is likely to happen if we get a U.S. law generally. But the big action for competition will be if the platforms are put under orders to do portability in a more systematic way.
Can you get into one or two case examples of sectors where there's been data portability requirements, or perhaps one of the sectors you studied to test your model?
Sure. Well, so one of them is this so-called interoperability rule that Health and Human Services promulgated as a final rule in March, and it's going into effect late 2020, early 2021. And it has at least two different kinds of portability requirements in it. One of them is that they want to make it easier for individual patients to use apps on their phone to free the data. So if you're a patient and you have a provider like a hospital system, or you have an insurance company, your health insurance company, this rule is trying to make it easier to get the data out of that HIPAA land, right? The protected health information, HIPAA regulated land, put it on your phone so that you can control your own data and then maybe do cool new things with it. Now, that's addressing information blocking. That's addressing the competition fear that the incumbents won't let the data get out. But holy crow, there's privacy and cybersecurity risks when data goes from inside a hospital database to being on a phone, maybe in an unregulated way. And so there's pretty complicated provisions in there about how to try to do privacy, security, and competition. Another part of the same rule is portability for the companies. So if you're a hospital system and you're using one software cloud provider, one health IT provider, and you want to move to a different provider, the rule says that the first health IT provider has to basically open it up and let you switch from one provider to another. That's a business to business change the whole system from point A to point B. So that same rule from HHS is trying to give individuals a right to portability, and is trying to have the possibility of an entire business shifting databases to a different place. So there's a lot of action going on there, and it's a much bigger rule than I think a lot of people have focused on yet.
Yeah, those seem like pretty strong and compelling reasons on both sides for not to have portability. You know, we need to protect patients' health data, and another reason to have portability is we want to allow them to take their health concerns to different providers.
Right. So
how did the interoperability rule? How were we able to get there with these strong competing interests?
Well, Congress passed the CARES Act a few years ago, and the CARES Act said we got to address this information blocking thing, that we have to free up data for healthcare. It was more a push towards openness for health data. There was a proposed rule. There were a lot of comments. HHS issued a final rule. And I'd say that the privacy people have continuing concerns that the privacy protections aren't good enough in the current version. But it's a rule. It's in place. It's supposed to be going into effect. And as people have experience with it, maybe there'll be reason for course corrections. But for now, we have, almost 20% of the U.S. economy is healthcare. We have this big rule for portability in healthcare. And I think more people probably should be paying attention to it and seeing if there's ways to fine tune it, perhaps in the next administration.
If there was one sector that you would say, we really need to look out for in terms of data portability, like what's the next sector where there could be big movement or that people are talking about right now?
Right. Well, so for U.S. financial services, there was a little known provision in 2010 in what was called the Dodd-Frank Act. That was the act to sort of reform Wall Street after the big 2008 and 9 mess. Mm-hmm. And Section 1033 of that requires portability from financial institutions, which again is about 20% of the economy. The Consumer Financial, CFPB, Consumer Financial Products Board, Protection Board, has issued a notice of advanced rulemaking in the fall of 2020. And it has an open comment period during the fall of 2020 about how to do portability for financial services. So this is a real live topic right now. And the goal for consumers would be maybe you get to move data from 6 different financial providers into one easy to use way to run your entire family household finances. But how do we do that consistent with privacy and security? So that's open for rulemaking right now. And we'll see what happens, whether they issue a rule in the coming year.
So we've spoken a lot about existing and future regulations. And I think the framework in your paper, you can correct me if I'm wrong, is a little bit focused on sort of how regulators should be thinking about ongoing legislation or future legislation. What about private companies that have a lot of data? Can they use this framework? How, when they're designing, their data portability policies, and how, if at all, would the framework change within a private company?
I hope that it could be very useful for instance, an online service provider when they're thinking about should we, we have a lot of users online. Should we allow portability in a certain way? And they could see competitive benefits. They might see it as a way to respond to concerns about antitrust worries. And then they can go step by step. How have we handled the privacy of the user? How have we handled the privacy of the third person? How have we handled when it goes out of our system to onward transfers to third and fourth parties? How is it taken care of? How have we handled authentication and encryption and standards? So I think that, this could be, a lot of companies in Europe do data protection impact assessments, or in the US do privacy impact assessments. And I think this really works for a company to do its portability impact assessment and go step by step and come to some view about what to do. And if they do it, what are some of the pitfalls?
Absent regulation at the federal level, do you see or federal or state level, do you see companies coming together and developing data sharing proposals in the absence of a law requiring them to do so? Mm-hmm. Is it in their benefit to be thinking about these things on their own?
Well, so I think the most prominent example is something called the Data Transfer Project. That's been led by some companies you've heard of, like Google, Microsoft, and Facebook. And they have, you can go look it up, Data Transfer Project. They have an open source approach, which is expanding the number of ways to move data more seamlessly from one platform to other places. And it's designed for smaller companies to be able to accept the data, and for individuals to be able to use these tools to move data from some of the larger platforms, especially, to more different places. So that's been, these are companies that have gotten antitrust attention and are under a lot of scrutiny for a lot of different reasons. But the Data Transfer Project is a public set of efforts to try to make portability more simple for real users. And people can look at that as an example.
Yeah, it certainly seems like there's a lot going on right now in this area, whether it's in the private space, in the government space. And that's why I think your paper is a great way for everybody to sort of really get at what the issue is. Like, let's talk about this on a specific level and try to see if we can come up with some solutions. So thanks
Great.
For sharing this with us today.
Well, I'm glad it's helpful. That was the hope.
So Peter, you're not quite off yet. Before we let you go, we want to ask you 3 questions. 2 we ask all of our guests. The first is to tell us something interesting about yourself that we wouldn't know about you if we just knew you professionally.
Well, I don't know if this is too professional or not, but the year after college, I had a chance to go to Belgium and be there for a year, sort of studying, mostly trying the beers. In those days, Belgium's about the size of Maryland, and it had 300 different brands of beer in Belgium, and I was only there for 200 days. So I faced a challenge.
Yes.
But what I'd say about it is I was hanging out and I found some courses in something called the Institute of European Studies, and it just seemed interesting. Like this, Europe's putting all these rules together about a new legal system, and I thought it was just for fun. And later in life, I turned out to be writing about Europe and the United States and how to do all these things. So what I thought was not professional preparation, I thought was just sort of interesting liberal arts, turned into background that helped me later in life. So you learn things from places you never really expect.
That may very well answer our next question, but happy to take any further thoughts. If you have any advice for students, your students or others, or younger lawyers or academics who are looking to do what you do.
Yeah. So I have students come talk to me and say, what should I do with myself? And one of the things I say is, first of all, do things that you're good at. It's just going to be easier. You're likely to have things work out better. And also do things that you like. So if you find yourself just enjoying one of your courses or one of your activities, and especially if you turn out to be relatively good at it, often they overlap, that's a pretty good guess that that's a direction to go to. So if you're doing something you don't like, well, then you better have a good reason to stick with it. If you're doing something you're not good at, maybe you want to be a singer, but you can't sing, you're going to face obstacles. So I'd say that's what I usually start with. Then beyond that, if you like it and if you're good at it, develop passions, find areas that are happening that you can be part of. And then you're part of the community that's working on this stuff. And then you'll maybe find chances to work there some more.
Great. Wonderful advice. So now for our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
So Peter, in normal times, we would actually have a physical hat that we would hand you and you pick out a number. We're obviously doing this virtually. So if you could pick a number 1 through 25.
24.
24. Okay.
Yeah.
It is getting chilly now, but what is your favorite warm weather activity?
Favorite warm weather activity? Well, I've gone through injuries that have taken me out of I used to play tennis and now my shoulder's gone, and I used to play soccer, but now I'm 60. So I think my favorite, I keep trying to, so I picked up golf, in my 50s, and I'm getting better. I've gotten all the way to mediocre. So I'd say
nice.
Getting better at golf and having a sport I'm getting better at the age of 62 is my current favorite warm weather activity.
And is there any new cold weather activity that you want to pursue this upcoming season?
I grew up in Albany, New York, and I love winter. I have married a woman of Cuban-American background in Georgia, and she thinks it's cold when it gets to 55 degrees, and I'm still wearing my T-shirts. So I don't get cold anymore, and I sort of miss it, but I really love my wife, and I like my life. So I'll just do without the cold, at least as I define it.
One of my colleagues has a house in Georgia, and he does a polar swim every year in Georgia. And I was like, that's not a thing in Georgia.
Oh.
Yeah, you better put quotes around polar, I think.
Yeah, exactly. Well, Peter, thank you again for joining us today. And to our listenership, thanks for tuning in. We'll see you next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.